This is Will Trackman, General Counsel of Mountain States Legal Foundation. We have some terrific guests, both attorneys and clients, on the line today to talk about one of our prominent cases, the Native American Guardian Association case, which is being litigated right here in the state of Colorado. We are going to introduce our attorneys and our clients. We're going to talk about some of the theories of the case and the important legal issues at stake. And we're also going to talk about the posture of the case, where things stand, both where we've been since we filed the case in November, where we are now. We just got back from court this morning, and where we're headed over the next few months. We actually are going to have to await a ruling. So stay tuned for a lot of very important updates on how things are going to proceed over the upcoming months. With that, let me introduce a few folks. On the line with me here today are Eunice Davidson, the president of the Native American Guardian Association, Demetrius Mattis, who's also a member of the Native American Guardian Association and one of our named plaintiffs in the case, Joseph Bingham, who is our senior attorney with Mountain States Legal Foundation and with me on the case, and Aaron Earhart, who's an associate attorney with Mountain States Legal Foundation, and we had the privilege of going to court together this morning to argue about the scheduling of the case. So we are looking forward, all of us, to walking through this case and answering your questions. If you do have a question, we are going to do a Q&A session at the last maybe 10, 15 minutes. So write it down, keep it in mind so that you can ask it, or go ahead and put it in the chat box or the Q&A box already. And we will get to it at the end of our discussion. Before going any further, though, I do want to invite Eunice and Demetrius to introduce themselves personally and talk a little bit about their story, their history, and why they wanted to get involved in litigation. You know, getting involved in a lawsuit is no one's idea of a picnic, and getting involved in federal court in a case that can involve a lot of time and energy is no one's idea of a fun experience. So I want to turn it over to them to talk about their story and why they decided to get involved in this case. So Eunice, I'm going to start with you and give you the floor.
Okay. Yeah. Hi, everybody. As Will said, my name is Eunice Davidson. How do I start? I became involved with NAGA back in 2014 because of what happened to our fighting Sioux name at the University of North Dakota. And we, my tribe, our committee, we formed a committee when the NCAA came out and said that we had to ban our Sioux name. So we got a committee together, formed. We had a leader, John Chasky, and we decided to try and put a petition out to have a vote on it, because they said if we didn't vote, they were gonna have to retire the name. Well, we went ahead and did that, and we got the petition on, and we forced it on the ballot with our tribal chairwoman. And the outcome in 2009 was 70% of our people, the largest voter turnout ever on a reservation, to vote to keep the Fighting Sioux name. And when that happened, it was outrageous what happened to our people and our tribe. The university, I always call them the elitist on the university, these professors, went after our tribe with everything you could imagine. False stories, false narratives about us. They called us uneducated. They called us stupid for doing that vote. They said if we were more educated, we never would have voted that way. That really upset me. They were trying to get rid of the Sioux name, and they wanted to blame the Sioux. So when that happened, there was no other way. The media was against us. We couldn't get anything out. They take little snippets out of long stories that I and John Chesky, our committee, would talk about. So I ended up writing a book. I just thought the only way to get out was write a book about it. It's called Aren't We Sioux Enough? And I tell every inch of the way that we went, every step of the way. We went to court. We were in district court. We were at the state Supreme Court. We were in federal court, and every court just dismissed us and said we had no standing, even though we were the focal point of the whole thing. So that really upset me. So then when I start getting on social media, I start meeting other Indians in the country who were very upset with what was going on with the Redskin name at the time and with all these names. And we said, we have to do something. So there was another guy by the name of Mark Yellowhorse. He's Navajo from the Navajo Nation. And him and I start talking, and we got involved with another guy who was not Native, but he felt the way we did. So we start going on social media talking about it, and we start getting just hit left and right with people from all over the nation asking us to help them to stop this. And many of them were the Native Americans, many Navajo, many of the Apache, many of my Sioux people, South Dakota, North Dakota, Minnesota. But anyway, that's how I became involved with this issue. And I just think what's going on in this country is that our voice on our side of the issue, we're not being heard. We aren't being heard at all. And they block us, they censor us whenever we decide to come out and speak about anything. I was on a show this morning out in Connecticut and just talking about the story in North Dakota. And when I finished, the guy was pretty happy with everything I had to say. He had no idea. He said, I've never heard from an American, an Indian before about this issue. He said, we're the ones that they should talk to. So after I got done, I listened to the show a little bit more. And there was a lady from the NAACP that came on, and she was talking for us, telling people how we felt. And I thought, how can you come on and say something about, stay out of our lane, get in your own lane. We aren't talking for you. So anyway, but that's why I got involved. And when we started gaining traction with people around the nation with our Native American Guardians Association, then we realized when they start banning these names and images, like in Maine and Washington, Nevada, and Colorado, we thought we have to do something. We've got to stop this. We can't let this go on, because I feel it's going to cause genocide to our culture. We are the smallest minority in this country, and I don't want to see that happen. I don't want to see us forgotten, and that's what's going to happen to us. We've talked to some people at the Utah Utes who totally support the Utah Utes, Northern Band and Utah, and they support the youth name at the university. And he said right now, he said, those are the things that names and images are the only thing that keep us relevant right now, because we are the smallest minority. So anyway, I won't talk too long, but anyway, that's just kind of why I joined and why I'm in this lawsuit. And I pray to God that we win.
Yeah. Well, I definitely want to dive in deeper to some of the things you just said, but let me introduce or have Demetrius introduce himself. Go ahead, Demetrius.
Hi, my name is Demetrius Mattis. I am 39% Dene or Navajo. I graduated from Lamar High School here in Colorado. Lamar, our mascot was called the Savages. And when Governor Polis introduced this bill, SB 116, he basically, like overnight, just decided we're going to eliminate all Native American mascots from high schools and imagery and names. I am a former Marine. I'm a small business owner. I manage a condo complex here in Denver. My biggest issue with this is being that I was never ridiculed or belittled because I was Native. I never had anybody in high school bully me because of our mascot. And I, like Eunice, I believe that the Native Americans don't have much left anymore. I mean, between the reservations and what little there is representing Native Americans, we're slowly dwindling away, and people are trying to erase my culture, and they're trying to eliminate it, thinking that they're actually saving us when they're really not. Every time I hear somebody say, well, it's bad imagery and it's derogatory, I think in my head, when were mascots ever bad images? When were they ever not inspirational and motivating? Nobody ever picks a mascot to be derogatory. Now, don't get me wrong. Over the years, there have been some bad images. There have been some bad caricatures. But that's what NAGA believes in, is that they believe in teaching people the proper way to uphold Native American imagery and uphold Native Americans and to represent ourselves proudly. We're not trying to erase our culture. We're not trying to wipe us off the face of the earth. For some reason, this woke culture is. And anytime anybody tries to erase another culture, it is just ridiculous. Every culture has its meanings. So for me,
sorry to interrupt, but I want to get more deeply into that. I'm going to have Aaron share some of our slides that we're going to walk through, and I'm going to ask for your take on some of the things that the Colorado legislature thought they were considering when they enacted this bill. So definitely, I'm going to return to you and ask for your take on a lot of these ideas.
Okay.
So here I'm going to just introduce the bill that we're talking about was SB 21116. It was a ban on Native American quote unquote mascots. As Demetrius just referred to, NAGA does oppose racist caricatures. Some examples are like Chief Noklahoma. It's not just, anything goes, but there's a big difference between just having the imagery and having a caricature of a race. So we put the word mascots in quotes. I've already introduced the attorneys and the clients here. With that, I'm going to turn it over to Aaron to talk through some of the details of the law that is the subject of litigation.
Great. So the law that is the subject of this litigation is SB 21116. It passed the Colorado legislature last year and was signed into law by Governor Polis on June 28th, 2021. And it requires public schools to retire American Indian mascots, as that is defined in the statute, by June 1st of this year, so just a few months from now. There is an exception if a school in a federally recognized tribe with ties to Colorado, there are 48 such tribes, have an agreement in place, then the school can keep the Native American mascot for as long as they have that agreement in place. But for each month that a public school continues to use an unapproved Native American mascot after June 1st, the school will be fined $25,000 a month, which is a lot of money. And there are currently, I believe, 26 schools that the Colorado Commission of Indian Affairs has identified as needing to change their mascots or be subject to that $25,000 a month fine.
So the statute defines mascot really broadly to include mascots that we would think of as mascots, but also a lot of things that aren't mascots in like standard usage of the term. So it doesn't just define like sideline caricatures as mascots, but it's any name, symbol, or image that depicts or refers to an American Indian tribe, individual, custom, or tradition, whether that's a mascot or a nickname, logo, letterhead, or team name. So if your school is named Sitting Bull High School, then you can't have that name in your logo or letterhead potentially under this bill.
So these are the plaintiffs. So you've already met Eunice, who is the president of the Native American Guardian Association, and Demetrius. We're also representing several other plaintiffs, including 2 students. We've identified them as John Doe and Jane Doe, who are students at Yuma High School, whose name is the Indians. And they are alleging, in addition to the constitutional violation that we'll talk about in a second, the school is going to have to take down a number of images related to their culture. So they're going to have to see the walls of their school stripped of murals, of art, of jerseys from championships past that say Indians, all taken down because of SB 21116. We're also bringing a case, filing on behalf of Chase Robideau, who, like Demetrius, requested that his local school not change their name, but if they are going to change their name, at least honor a Native American by naming the school after a historic figure connected to them. And the school district there said, nope, that would violate SB 21116. Even an honorific name would be a violation, and we don't want to pay $25,000 a month. And then we've also sued on behalf of Donald Wayne Smith, who is a pastor in Yuma and was a substitute teacher. And he's alleged that he can never substitute teach without facing a hostile environment. And especially right now, as COVID-19 and the Omicron variant are wreaking havoc on school populations, and substitute teachers are in desperate need. Why are we telling one teacher here that in order to ever be of service to his community, he would have to face and suffer a hostile environment? And then, of course, NAGA, which is working across the country, including in this case, to increase education and increase the recognition of Native American heritage throughout the country, including by reclaiming. Even if a mascot is quote unquote offensive, that doesn't mean that you get rid of the mascot. That means you educate. That means you reclaim the mascot and make it something that you're proud of and that you can teach through. So that's why NAGA is in this case.
Okay, on the other side, we have the defendants. We originally had 6 defendants, including Governor Jerry Polis, Colorado Attorney General Phil Weiser, Colorado State Treasurer David Young, Commissioner of Education for the Colorado Department of Education, Katie Anthes, Georgina Owens, who is the Title VII State Coordinator for the Department of Education, and Catherine Redhorse, who is the Executive Director of the Colorado Commission of Indian Affairs. We recently, however, reached an agreement with the defendants to dismiss all of the defendants except for Ms. Redhorse, who, as I just said, is the Executive Director of the Colorado Commission of Indian Affairs and has been facilitating a lot of the Commission's hearings where they are taking evidence from the schools regarding their potential name changes, mascot changes. And she is the one who it looks like will have the enforcement authority under the statute and needs to be the one that is sued.
Yeah, I would just add, this is a great agreement. So we ended up dismissing the governor and the attorney general and a few other folks from the case, but the state agreed, number one, that Ms. Redhorse, Catherine Redhorse, number one, everything we've asked for, we can obtain by keeping her in the case. And number two, they've agreed to our request to depose Ms. Redhorse as a representative of the Colorado Commission on Indian Affairs for 7 hours. So we are going to depose Ms. Redhorse and put her on the record for 7 hours and be able to ask her every question that we need to in order to obtain evidence in this case. So that's a huge win for the plaintiffs going forward.
And we get everything we want from having Redhorse as a defendant because the reason we initially sued all those people is that the law doesn't make it clear who has the authority to enforce it. When you sue over the constitutionality of a law, you're not actually asking the court to quote unquote strike it down. That's a common misperception. You're asking the court for an injunction that prohibits the person in charge of enforcing that law from enforcing it. So the law stays on the books, it just can't be enforced anymore. So if we get an injunction against Ms. Redhorse, then Colorado said that she's the only person who could enforce it. So that's all we need. The most glaringly offensive thing about this bill is that that it effectively prohibits honorific uses of Native American names in school names, or at least if you have it in your school name, you can't have it in the letterhead. And so the state's argument is that none of our plaintiffs have standing because none of them are directly harmed by this bill, because there's no right to have a school named the way that you want to have it named. But that really proves too much because under the state's theory, if Colorado passed a law saying you can't name any schools after Black people, then nobody would have standing to sue to challenge that law. They could effectively ban the every school named Martin Luther King Jr. High School, and that would be an obvious equal protection violation. It would be obviously unconstitutional, but Colorado is saying that nobody would have a chance to challenge it in court. There's nothing federal courts could do about it.
Yeah, let me turn it over to Eunice and Demetrius. I mean, you can see these images where Martin Luther King, a prominent African-American man, is featured on this banner here, and where Cesar Chavez, the name of a prominent Hispanic American, is featured on a school's letterhead. You know, if these were Native American individuals, these would probably be illegal under SB 21116. Obviously, the tribal compact provision, and I guess you could imagine a school saying we're just going to pay the $25,000 a month penalty, but ostensibly illegal. You know, how does it make you feel to see your race targeted in that way?
Ridiculous.
Yeah.
It's it's really disheartening. It really is. For anybody, for basically anybody to speak on Native behalf is what really, really chaps me. When we talk about that we can sue Miss Red Horse, the only Native American that we can actually go after, that kind of disheartens me as well, because here we were going to go after Polis and after Wisner, and I don't want to make it a race thing, but all the white guys got out scot-free, and we're going to end up suing a Native American. So it's not a winning battle anywhere where we look, but at the same time, we're standing up for what we believe in. And we believe that these images and wording, there's nothing derogatory about it. There's not. People aren't getting hurt over these images. And even by erasing them and getting rid of them, nobody benefits from that. Nobody benefits from it. So for the schools to have to spend upwards of $500,000 to change all this imagery, the schools don't have money as it is. They're already on financial shortfalls as it is. To waste $500,000 to change imagery and names, to me, is ridiculous. We got more important things to worry about in schools than some imagery.
Yeah. Eunice, what do you think?
Well, I agree with Demetrius. I think to single out the American Indian on this, to me, that is discrimination. When they're only going after one race of people. It is. And as far as us having to just go after this Red Horse, everything that I've done over the few years, the people that I've had to deal with are these school boards. And the majority of them are not Indians. They are non-Indians who are wanting to get rid of these names and images. So, you know, I have to think, like with Demetrius, why is this Governor Polis and these other white people, why are they getting off free and, you know, getting a pass when really he signed the bill? I mean, you know, how many of the representatives in Colorado are Indian doing this?
Yeah.
So, you know, I just think this is wrong. I see it as discrimination. I'm going to call it as I see it, going after one race of people. And we are the smallest minority, like I've said before. Why don't we have a voice?
Yeah, I mean, it was stunning to me when I read the statute, and Joe just showed it to us before a minute ago, that the name of a Native American person cannot be on your letterhead. How, yeah. I mean, or sorry, an image of a Native American person cannot be on your letterhead, and then the name of a Native American person can't be in a number of other places around your school. It's just crazy to me. No school obviously would choose a Native American individual as, you know, to name even in an honorific way with those restrictions. Why don't we go to the next slide? So this is the legal claims that we've brought in the case. Number one is the 14th Amendment right to equal protection, which is just saying that, look, you're treating Native Americans differently than you're treating other racial groups, as we just established. The second is a similar claim. It's also equal protection. It involves a unique claim based on political process. The state has said to us, look, if you don't like the way that we're doing this, why don't you just go to the Colorado State Legislature and get them to change the law? That way you can get what you want. Of course, no other racial group has to face such a daunting legislative gauntlet. You know, if you want to name your school the Vikings or the Celtics, you don't have to go to the Colorado State Legislature in order to do that. But if you want to name your school the Indians, you have to get an exception from SB 21116 passed through the state legislature and signed by the governor. It's the only racial group that has to go through the full legislative process in order to get an honorific, a name. And remember, we have two plaintiffs that tried to do this with Tall Bull and Black Kettle, and both times the school said we can't do that. That would be a violation of the state law. You heard me refer to the students who brought claims under Title VI for hostile environment, that they're going to see schools stripped of their walls and murals. Already during the testimony that has occurred before the Colorado Commission on Indian Affairs, we heard that Campo School District destroyed their mural of Indian warriors. So what Eunice is saying is absolutely true. It is a destruction of Indian culture, and it is an erasure of Indian culture. The school did this and presented this evidence in order to be in compliance, somewhat proudly to the Commission on Indian Affairs, saying, look how well we're complying with your law. And then we've sought injunctive relief against the state to preclude them from enforcing this law going forward.
Can I interrupt you for a second?
Yeah, of course.
So what happens? Why is this just the schools? What about like Arapahoe County and Arapahoe County's, all their buildings and their signages on their buildings? They have an Indian chief on the Arapahoe County buildings and all their signage. What about all the cities in Colorado or towns named after Indians? I mean, where does it stop? Really? Where does it stop? To go after schools, to me, is the low blow. But
well, it's a great point. I mean, look, there's a lot of schools that are named after their localities. So all the schools in Kiowa, all of the schools in Arapahoe that are named after the county, those are all in violation of SB 21116. Now, the Colorado Commission on Indian Affairs hasn't identified probably tens of schools that are in violation of the strict terms of the statute. And you can bet that Ms. Redhorse is going to be asked those questions at her deposition. So, but it's a great point. Why don't we go on to the next slide?
All right, and I'll allow Eunice to say anything else she wants on this. As we've been talking about, NAGA believes that banning mascots erases Native history. I'll let Eunice talk about what NAGA's definition of a mascot really is. But as we've said, this bill goes too far, this law goes too far. It doesn't allow naming a school after a Native American individual as an honorific without being subject to these fines. It does not allow Native Americans to reclaim or reappropriate their history, as, for example, the LGBT community has done or tried to do with the word queer. And it decreases the visibility of Native Americans in non-Native spaces by erasing what for a lot of non-Native students would be one of their only exposures to Native Americans, and seeing imagery and being exposed to Native history in their schools. Eunice, do you want to say anything about how you guys at NAGA define a mascot or about the erasure?
Yes, I do. Everybody, the opposition calls it a mascot because we feel it's a really derogatory term used. A mascot to us is somebody who's dressed up as an Indian, dancing along the sidelines, or performing as an Indian and not being an Indian. So to us, like on my reservation, we have logos. on my reservation, we have the Four Winds Indians, and it's a depiction of a warrior, an Indian warrior. And on our other school, we have on the reservations called the Warwick Warriors, and they have a headdress of an Indian. We never call those mascots because they aren't. All they are is just a depiction, a picture of somebody. A mascot, many schools got rid of mascots years ago because a lot of them were not the best depiction of American Indians, and we didn't like that either. And like Will said, we don't go along with every mascot. I mean, we don't go along with every school. It has to have respectful, a name, a logo, an image. You have the Nike logo. That's not called a mascot. That swoosh sign, that swoosh mark, that's just a logo. The same with everything. Almost every school that we've talked to has a logo. They don't have a mascot. So that term mascot is really used to make it sound even worse for these schools.
And I'll just add to that what you said about having erased some of the more negative aspects of this stuff. In the past, a lot of the schools have testified to the commission that they may have had stereotypical imagery and chants in the past, but they've already years ago taken steps to eliminate that. But they want to be able to keep the more positive imagery or the relationships with the community.
Yeah, they use it to honor us. It's nothing to make fun of us or, and you do have some of these fans who do go out and do a dumb thing, wear the headdress and, say stupid things. And that's just the fans. You can't control everybody. I mean, the school basically puts it out there to honor us, to remember us.
And there's not too much to say about this slide. It kind of speaks for itself. But just to emphasize, it's really impossible to imagine the state in 2021 or 2022 going after any other race, targeting any other race for this kind of erasure. It's really unique to how the state wants to treat Native Americans, that it wants to erase their culture from schools. And I think this image was in our complaint with an example of getting rid of the Indian and keeping the land.
Yeah, I've seen that. A lot of our people on the reservation don't even buy that anymore because it doesn't have the picture of the Indian princess on it.
But can we go back to that slide? By removing her, did anybody benefit from that?
Right.
I didn't. I'm Native.
Yeah.
Didn't benefit me one bit by removing it. So why remove it? If anything, it only hurt us because now she's gone and you don't even see her anymore. But that's what I don't understand is who in their right mind thinks by removing that image because it's offensive, and I don't know how it's offensive, is going to help somebody.
Yeah, that's the first time that I've actually included a meme in a federal complaint. But you're right, Demetrius, it's not clear. So why did Mountain States take this case? Obviously, we are pleased to represent NAGA and Demetrius and the other plaintiffs. Historically, we have a prominent space in the equal protection area. We represented Adirond in one of the most prominent equal protection cases in our nation's history, Adirond v. Pena in 1995, where the Supreme Court ruled that racial classifications must meet strict scrutiny. That there's no difference between quote unquote benign racial discrimination and other forms of discrimination that are invidious. This case also implicates some First Amendment issues, which is another area where Mountain States is prominent. For instance, can the government decide when speech is offensive? We also recently filed a brief in the 303 creative matter, which involves a website designer who declines to develop websites for same-sex marriages. So we are in the First Amendment space and thought that this case, which has some First Amendment implications, was important for us to get involved in. We also think that, as Eunice mentioned, that these laws are being replicated in other states. It's not just Colorado that's getting involved in these sorts of erasure type issues. And so here in Colorado, it was important to take a stand. And also the idea of cancel culture. You know, if you can't say Indian today, what is it that you can't say tomorrow? And so we felt that these are the sorts of implications that justified Mountain States taking this case. I'm going to move us along for time in order to talk through some of the media attention that we've already gotten. And then we'll talk about what's going on with the case and then open the floor for questions.
All right. As Will just said, there's been quite a bit of media interest in this case. So you can see some of the headlines that have come out recently. And there have been several since we made this slide that have been published more recently. And it's been great exposure to see what the schools are having to do. I think one of the most egregious things that was in an article recently was that there is one school district in Colorado, Mountain Valley, that just 3 years ago did a huge initiative, a new building, and included a Ute artist to create their logo, had a Ute representative at their groundbreaking. But now the Ute tribe will not enter into an agreement with them, so they're going to have to expend all the money and effort, even though their logo was respectful and created historically grounded with the tribe, that they have to change it. It was on their agenda at their school board last week.
Yeah. All right. Why don't we go to the procedural posture of the case? Joe, I'll take the last 3 bullets. How about, do you want to go talk through the first few?
Okay, we filed our complaint in November and moved for an injunction asking the court to immediately stop any enforcement activities because schools are already investing money with the June deadline in mind. And the closer we get, the less likely it is that we'll manage to save any Native American representation because schools will have already made that investment and not want to go back. The court rejected our motion. We briefed that at the end of November over Thanksgiving, and it was denied December 1st. And did you want to take the last 3 you said?
Yeah, so after the preliminary injunction motion was denied, we filed an appeal the next day with the 10th Circuit Court of Appeals, which is the appellate court based here in Denver. And then after that, we moved for an injunction pending appeal. So we basically said, look, while we're appealing, we would like you to stop the Colorado Commission on Indian Affairs from doing anything to approve mascot changes or change the status quo, because as schools are changing their name, there's no way to get it back. If we win this case at the end of the day, but schools have all changed their mascots, it doesn't really secure a victory because schools are not going to go back. The briefing on that motion was completed on January 6th, but we continue to await a ruling. In the meantime, the district court case is ongoing. So we're litigating now on 2 fronts. We attended a scheduling conference just this morning. So this is breaking news here. The defendant, the state of Colorado, has asked for dispositive motions to be due June 30th, which you will notice is after the statutory deadline of June 1st. So they would like that their brief not even be due until after the deadline for compliance has already passed. We push back hard on that, asking for briefs to be due February 28th initially, and then reply briefs due early April. So we will see. The judge took the arguments under advisement. We are awaiting a ruling on that, but obviously we want to get a ruling as soon as possible because it's important that schools know whether they have to comply or not. Obviously, if the 10th Circuit rules in our favor on the motion that was finally briefed in January, that will change everything and we'll have a lot more time. But we are very, very interested in getting this case resolved as quickly as possible because schools are in the process of trying to avoid those massive $25,000 a month penalties. So we are definitely trying to move quickly. I saw that we do have one question pending. If you have other questions, please add them to the chat box. We are interested in answering whatever inquiries you may have about the case or what comes next. So please go ahead and enter those. The very first question is from Jay Rowe. What Native nations are supporting your lawsuit? So in a lawsuit, you can have amicus briefs. You can have people intervene on your, either intervene or file briefs on your behalf saying we support this or as a friend of the court. The case has moved so quickly that no one has filed any briefs either on behalf of the state or on behalf of the plaintiffs because it's hard to get in at any stage of the case. So schools haven't entered the case on either side. and no one besides the parties has entered. In terms of, anecdotal, what people are saying, I'm happy to open it up to Eunice and Demetrius, what they're hearing through the grapevine. What I'm hearing are people saying it can't really be true that you can't name a school after a Native American person in Colorado anymore. Is that how could they have written the law so sloppily? And I keep having to tell them, yeah, it's true. You can't put a Native American person's on a logo, and you can't put their name on a logo and their image on letterhead. So Eunice or Demetrius, if you're hearing anything else from the grapevine, please go ahead.
Well, I've got a few emails from some people from Colorado that are really concerned about this, and they're meeting with their school boards, their superintendent, and they're being pushed to change their imagery and all that, and they don't want to do that now because, like you said, they want to wait and see how this lawsuit goes before they go into all that. And if they're made to change it, then they're not going to be able. I mean, it's going to cost money to change everything back again. So I don't know. I know we've talked with, I would have to say, quite a few people around the nation who say, why don't you have an amicus brief? Why don't you have somebody standing supporting yours? And I think that we can get people to do that. I don't know, if I was in that one with the Redskins, the amicus brief. I was one of the plaintiffs in there that stood with them. We were individuals. We weren't anybody, leadership or anybody from any tribe. We were just actual members, tribal members that stood with that. So, I would like to see an amicus brief. I don't know if that's possible or not. You brought it up, so I just wanted to talk about that.
Yeah. We got a question. Which other states are replicating these types of bills? I know I saw Oregon had something similar. I'm hearing that New York is trying to pass some sort of administrative regulation through its Board of Education. Demetrius or Eunice, are you following any other states that are moving in this direction or that you've heard of?
I know Vermont's thinking about passing a bill, but they're going after all images for sports teams, images and names, it sounds like. But I don't know if that's going to go over very big. I know, Demetrius, do you have anything?
No, not really. As you know, we went to Iowa, but the state isn't passing anything in Iowa. It's just the school board there. It's going to spread like wildfire, and I don't know why. But if we lose Colorado, it's basically the downfall. It is, because every other state will just follow suit.
Yeah. Next question.
Filed or passed a similar bill this spring, and that Maine also has one on the books, just for a couple other states.
I'm sorry, Aaron, it's hard to hear. I'm just going to move on to the next question. The next question, should tribal politicians and activists be the deciding factor, or should we listen to the majority voice of rank and file Native Americans? Eunice, I'm just going to send this directly over to you. What do you think?
I think it should be the rank and file American Indian. On my reservation, if we wouldn't have pushed that vote like we did, our tribal leader did not support names and images, we would have been on record as not supporting them, when in fact our vote totally told a different story. So I really believe that it should be tribal members, and actually tribal leaders should allow their people to vote on this. Everybody should have a say on this, not just a few of them, especially not just the tribal leaders, and most of them, for whatever reason, don't advocate for them.
Yeah.
So I think.
Well, that relates to the next question, which is, have any tribal governments gone through the process of passing a resolution to comment on this law? I mean, this lawsuit was filed in November, so it hasn't been that long since it was filed. Are tribal governments passing resolutions addressing this lawsuit? I'm going to again say, well, it's been, it's been a quick process since November, and it is moving along speedily. So it's not really clear that anyone could pass a resolution that quickly. And then the next question, I guess, from the same questioner is, who is financing the lawsuit? So Mountain States Legal Foundation is a nonprofit pro bono law firm. So we rely on the generosity of our donors to fund our operations. And so we aren't taking any money from NAGA or the plaintiffs. We are 501c3, and we look forward to everyone on the call going to our website at mslegal.org. And if you are so inclined to contribute on behalf of, for this case or other cases in our general pro-liberty stances in our litigation, you should do so. And we are definitely looking forward to having you as a partner and a cooperative presence in all of our work. Again, that's mslegal.org. Any other questions before I close up shop? I do have one comment here, which is that dozens of Native nations showcase their support by keeping exact names and images on their own reservation schools. So Eunice or Demetrius, I'll give you the last word here. Are there reservation schools that have Indian related names that are keeping those names currently?
I know on the Navajo Nation, there are schools with Native imagery, and I've seen them, and they're, as far as I know, they're keeping them. But what happens when that state, like take for example, New Mexico, says, oh, wait a second, you can't have Native imagery at your school? I don't know what they're going to say. Like, that's a Native reservation. That's a Native school. Like, you're going to tell them that they can't do that? Like, come on.
Well, I think we'll close on that note. So thank you to everyone, all of our attorneys and our clients and all of our questioners and all of the media folks on the line today. We really appreciate your attendance. Again, if you want to read more about the case, our website is mslegal.org. We're very pleased that everyone came today. And with that, I will close us down.
Thank you.
Thank you.
Thank you.